The ultimate guide for wholesaling laws, regulations, and bans. Guys, I'm Zach Ginn. I've done over 2,000 wholesaling real estate deals, and I am the largest wholesaling real estate coach, mentor on the planet when it comes to wholesaling real estate. I don't say this to brag or to bring my ego into this. I'm simply stating the facts. I have taught more wholesalers how to get their first deal, make their first $100,000, and make their first $1 million wholesaling real estate. Not because I'm the richest wholesaler in the world, but to this day, I'm still the only one willing to give the information out for free. As somebody that wholesales throughout the country, I get inundated every single day from my hundreds of thousands of followers and students in freewholesaling.com about the newest wholesaling law, ban, or regulation coming in to destroy wholesaling real estate. And every single day on my live streams, I get questioned, oh, I guess this law bans wholesaling. I guess I can't wholesale here. I see videos on the internet saying you can't wholesale anymore, or you can't do this, or buy my program and you do this thing. So what I'm gonna do today is do a end-all, be-all, painstakingly long step-by-step process of every single bill right now in the state legislators about wholesaling real estate or assignment of contracts, and then all the current passed and signed laws from every single state that has a law, regulation, or bill when it comes to wholesaling real estate. It pains me to make this video because of so much misinformation that's going on about what laws are in wholesaling real estate and what we as an industry should do. I'm going to give the information to you so you can make an educated decision. Now, if there's a regulation or law in the state, I'm going to give you my opinion on what other wholesalers and what I do to get around these laws, or what you can do to be in legal compliance. Now, I want to make this very clear. I am not a lawyer. I am not a legal representative. I am not a realtor or real estate agent. I am none of these things. I am a proud, unlicensed wholesaler, and I'm giving you my sole opinions. My lawyer made sure I say that. So if you are doing anything, including real estate or wholesaling or flipping houses or anything, always consult a title company and a lawyer or an attorney. Now, below in the description of this video, there are going to be links to all of the proposed bills and currently signed and legal laws when it comes to wholesaling real estate. Click there and follow with me and you can actually see the entire guide. I also included an entire comprehensive guide in my free real estate wholesaling course. Freewholesaling.com is my real estate wholesaling course with over 250,000 students who are learning wholesaling real estate for free step by step. So let's bring it from the top of the first proposed bill that has not been passed yet. Now, the links are below to see if these laws passed or not so you can stay updated. This is going to be HB 4754 in South Carolina. This is frankly one of the craziest laws ever and something that I don't think is really going to affect wholesaling real estate at all. Let's go below and read what we have to see here. Now, it's basically saying you need to get a real estate license or you're defined as a real estate broker if, on section 45 here, wholesaling, you can't do it if you're wholesaling, and the definition of wholesaling here means having a contractual interest in purchasing residential real estate from a property owner, then marketing the property for sale to a different prior to taking legal ownership of the property, advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under definition of broker and required licensure. Now let's break this down for an example here. So wholesaling real estate, from what I understand and what most people understand, is writing up a contract to buy the house, then selling the contract, not the house. You got to understand here, when you write up a contract to buy a piece of real estate, you don't own it. You just have a contract to buy it. You have what we call here an equitable interest in buying it. This is very important because if I am pretending like I own a house that I don't own and I'm trying to sell it, that's what a real estate agent does. That's what a real estate broker does. There should be a clear definition and a split between real estate agents, brokers, and wholesalers. I truly do believe, and this is a controversial statement, if you do not own a piece of real estate, but you are selling it on behalf of someone, then yes, I understand why you need to have a broker, maybe even a license. I could understand that. But us wholesalers are not selling other people's houses. We're selling something that we own, our contract, our freedom rights in the United States of America. This is so much different. And so that definition is completely different than what is written here. It's basically saying wholesaling is when you write up a contract to buy a house and then you're marketing the property for sale. So if someone says, "Oh, I caught you, you're doing this," well, no, I'm actually not marketing the property for sale. I'm marketing my equitable interest for sale. So clearly, I truly believe this law is null and void. It's changing the definition of wholesaling. So now every single guy and gal on YouTube is going to say, well, wholesaling's illegal. Well, their definition of wholesaling is illegal, but my definition of wholesaling is different. This law is as clear and cut as it comes in the state of South Carolina. Their definition of wholesaling is if you are marketing the property for sale when you have a contractual interest. Now, every single guy on YouTube or gal, wholesaler is going to think, oh, well, they actually have to change this law and then they can make it like this and this is what they meant. No, they clearly meant it like this. They're not trying to stop wholesaling in this law. What they're actually trying to stop is people pretending to be a real estate agent when they write up a contract to buy a house. That's kind of the funniest part here. Now, this is actually something called a Trojan horse. And you might be like, wait, Zach, why are you bringing up the Trojan horse situation here? Well, here's the truth. This law is not about us unlicensed wholesalers. Bum, 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 right? No, this is a law intended only for real estate agents. This is a law trying to ban real estate agents from wholesaling. Let's keep reading the law and let me show you the proof. If I'm a real estate agent and I write up a contract to buy a house and then I'm marketing the property for sale, then boom, I can't wholesale. Right here on section 40-57350, it basically says a real estate brokerage firm provides services through an agency agreement to a client is bound to the duties of loyalty, obedience, disclosure, confidentiality, reasonable care, diligence, and accounting set forth. Pursuant to the aforementioned duties owed to a client, a real estate brokerage firm and its sub-agents are prohibited from engaging in, representing others in, or assisting others in the practice of wholesaling. So this is just basically banning real estate agents for wholesaling. This law clearly states that some real estate agents are going to look at this like, oh no, this is trying to stop unlicensed guys. No, this is a law only for real estate agents. That's the funniest part. They're actually trying to show a clear line. They think if you're a licensed real estate agent, you shouldn't be wholesaling, but if you're unlicensed, you're good to go. This law clearly states here that real estate agents are prohibited from the practice of wholesaling. Now, some people might tell you they're trying to ban wholesaling and saying you need to have a real estate license to wholesale, and then boom, they're banning real estate agents from wholesaling. This makes 0 sense. That is like 5 comments I got today on my Instagram. Whoever's interpreting that doesn't understand what's going on here. This is a law clearly, number 1, on section 45 here, trying to show the difference that yes, you can be an unlicensed wholesaler. You just can't be a guy who writes up a contract and acts like they are selling the house, which is, you're going to see here a lot of laws about wholesaling. But this law is really funny. Then they clearly state in number 2 that you can't be a real estate agent. They are prohibited from assisting others in the practice of wholesaling or representing in wholesaling or just in the practice of wholesaling in general. This is amazing. This is a law not going after us wholesalers, but going after real estate agents in wholesaling. This technically is a law that protects me from wholesaling without a license. It's going after real estate agents and realtors. So when someone tells you that you need to get a real estate license to wholesale houses, be careful. The dominoes are falling. To become a real estate agent means you can't wholesale real estate anymore. I expect there's going to be laws in every state about being a real estate agent and not being able to wholesale. That's just a joke. But like, come on. This law clearly states us wholesalers without a license, we're good to go. We're basically fine. Again, talk to your title company, but this is business as usual from my interpretation. And yes, technically in this law, you can just double close, which is the art of buying the house, then immediately selling it with transactional funding. Sometimes you can use the buyers for transactional funding. It depends on the title company and the laws in your states. Now, I don't want to give a spoiler alert, but basically every single law that is introduced or every single law that talks about wholesaling real estate, we can all, for the exception of one, double close everywhere. And so basically that means still to this day, there's only one state that has a law saying that we can't wholesale without a license. There's no really loopholes around it. And I'm going to get very in detail about this because technically that's not even true. But let's go through the second proposed law in wholesaling that is not passed, it's just proposed, it's a bill. This is Oregon House Bill 4058. Now, this one's a very interesting law, and I ain't gonna lie, it's kind of weird. This is House Bill 4058, and basically what it's doing is it's not banning wholesaling real estate. It's actually trying to create a wholesaling real estate union or some association with their, quote, residential property wholesaling, where they're saying, yeah, we actually want to legitimize wholesaling real estate as a practice without a real estate license. Now, your average guy on the street is not going to tell you about this bill because it doesn't make them look good or serve their agenda. But I just tell you the facts. This law basically says, yes, real estate wholesaling is a thing, and we are going to do is we are going to create a registration process for real estate wholesalers to wholesale houses. Pretty much what it is. So it's actually looking to legitimize wholesaling real estate in the state of Oregon, not ban it like every single person tells you. Now, reading here, section 1, it says, number 1, market means to advertise or contract with another person or entity to advertise or solicit purchasers for the purchase of a property, either publicly or privately. So that makes sense. You know, I'm just saying we could still double close, but they're just trying to legitimize wholesaling real estate here. So let's go to section 3 here. Residential property wholesaler means any individual who engages in residential property wholesaling and is registered as a residential property wholesaler under Section 3 of the 2024 Act. Now, 4 clearly states here, residential property wholesaling means to market residential property for which the marketer has only an equitable interest or an option to purchase, and at a time of marketing, the marketer has held such interest or option for fewer than 90 days and invested less than 10 grand in the land development or improvement costs associated with the residential property. Now, it states here below that one act of this is sufficient to constitute engaging in residential property wholesaling within the meanings of this section, which means only to do one, you're going to have to be a licensed residential property wholesaler. Basically, they tell you have to have disclosures, you have to register. Now, you don't have to register if you are already a licensed real estate agent, if you're an attorney, or a power of attorney. Now, it also says to become a property wholesaler, you're going to have to be 18 years of age, pass a high school equivalency test, so having a GED, list all entities' business names and assume business names under which the applicant has conducted or will conduct residential property wholesaling in, and will only grant it to those who are trustworthy and competent to conduct residential property wholesaling in the interest of the public and only after proof that that's been presented to the commissioner. Residential wholesaler registration is going to cost $300 and a $300 renewal. Now, it basically says here what you have to disclose to the sellers, that you are going to, it says here you're going to enter into a written contract for a residential property wholesale transaction. The real estate agency shall establish the standards for proper residential property wholesaler, written disclosure requirements under the section, so they have to write it. Now, this disclosure has to be in 10-point bold type, stating that you're a residential property wholesaler, has only an equitable interest in the property being sold, stating that you do not have legal title, which makes sense. Explaining that you might not be a real estate broker, might not be a licensed appraisal person, and then if you are a licensed person here, a seller or buyer who enters into a written contract for a residential property wholesale transaction may cancel the contract without penalty, deliver of a writing of notice of cancellation at any time before 12 midnight at the end of the 3rd business day after the receipt of the residential property wholesaler written disclosure. Now, this law is very vague because this is for residential property wholesaling transactions, so double closing is not in this. And heck, in my opinion, it's a little vague what if I'm going to buy the house myself and then I decide to just assign it? Basically, the marketing or advertising to another person. So let's go back here to section 1 and see if I have to have this residential property wholesaling license if I'm just going to do a standard assignment of contract. Market means to advertise the contract to another person or solicit purchasers either publicly or privately. Now, there's nothing in this law saying that we can't assign our equitable interest. This law is only talking about the marketing of it. So if I don't market it, technically, could I assign it to another person if, let's say, for example, I just mentioned I'm buying a house. He says, I want to buy your house. I'm like, well, I didn't market it to you, but if you want to buy the house, I mean, I guess so. Is that legal? I don't know. We got to talk to a lawyer about this, or maybe have a title company clarify this. But according to this, in my interpretation, there's not a problem with actually assigning your deal to somebody. It's the marketing that they're trying to get regulated here, which honestly is not a terrible thing to do. So if you're not marketing or if you're double closing, you're probably gonna get around this no problem. Now, they do have some pretty stiff penalties. It's gonna be no less than $1,000, more than $2,500 for the first offense. And then there's just more fines. Nothing criminal, just fines and civil penalties. They're saying basically if they find you doing this, that they can give you a cease and desist, and they talk about here what the cease and desist looks like. And there's a lot more stuff talking about this bill here. We can't market our deals, but could I potentially, with this law, let me just think of a theoretical here. Can I get a list of cash sales, call a bunch of cash buyers, not actually marketing my equitable interest because I don't have a property under contract in Oregon right now, to say, hey, I saw you bought this house for cash. Are you looking to buy any more for cash? Yes, I am. I'm actually a cash buyer. Okay, perfect. Well, I'll put you on my list. Is there anything in this law saying you can't do that? No, not really, because maybe I'm going to double close and I'm actually looking for people to buy my double close deal, right? So it's like I can get a list of buyers. I can mention to them properties I have under contract, but I'm not saying that I'm selling my equitable interest to you. If they bring up that they want to buy it, is that marketing? It's not defined here, and you really can't define this. It's very interesting how this works. But I do see a lot of loopholes, and this is vaguely written because I don't think it's going to be enforced at all. But this is House Bill 4058. I don't really see it affecting wholesaling real estate too much or anything crazy. People are going to register, people aren't going to register. This is going to be a mess. But honestly, this is not a big deal. But the problem is, it's trying to make wholesaling real estate a legit industry where, yes, the government makes the money, not a private association. So people are not going to mention this bill because they can't make money off of you. And this is why you're never going to hear it outside of this YouTube channel, probably. Now, the next bill is proposed. This is Iowa House Bill 2394. And Iowa House Bill 2394 states residential property means real estate that includes no less than one but more four dwelling units. Wholesaler means a licensee or person represented by a license who holds an equitable interest but not legal title in a residential property for the purpose of selling the equitable interest to a buyer. Wholesaling is the practice of a wholesaler entering into an assignable contract with the owner of a residential property for the purpose. Let me highlight this. The purpose of marketing and selling the equitable interest. So this means if you write up a contract that has assignability in the contract and your purpose is not to only market and sell the equitable interest, and maybe your purpose was to double close it, then you're going to be exempt from this new Iowa law. It's basically saying that you have to be a real estate agent to wholesale real estate, but if you are double closing it, or maybe your purpose is different, then you're not really privy to this law, or you're not really the person being talked about here. Saying wholesalers it's saying basically now wholesalers must show disclosures that if it falls in that definition. So it says to do the wholesaling in their definition, you have to have a real estate license. And they got a $10,000 penalty if you don't do it the way that they say. But let's kind of talk about the purpose. Remember, they can't ban the assignment of contract. They can't ban wholesaling real estate. That is against the Constitution in the United States of America. So what they did here was saying, yes, you can't do assignment of contracts if your purpose of marketing and selling the equitable interest. Let me tell you this really very carefully. The word "and" is very important because it shows both things, one and two. So if technically here, the practice of wholesaling is a wholesaler entering into an assignable contract for the purpose of selling the equitable interest, you're good. You can technically do it for the purpose of marketing it. But if you are not selling it, you are outside this legal definition. These are so poorly written because they can't actually write any laws of substance for wholesaling. So this is really stupid again, which it really has no big change on how we wholesale in the state of Iowa. Again, this law won't really hit anyone's agenda, so no one's going to talk about it. Still double close, talk to an attorney in Iowa. Everyone knows my spiel about this, but we should be fine here. Now, last but not least, I actually did a video on this HB 917 in Virginia, this other proposed law. And this one has, quote, the most teeth that I could see on any proposed law for wholesaling. This one's basically stating that anybody who sells or offers to sell, buys or offers to buy, negotiate or otherwise deals in real estate contracts, including assignable contracts, on 2 or more occasions in any 12-month period for compensation or valuable consideration has to be licensed. So the basic definitions of this, I'm not going to bore you with it, is if you are wholesaling for the purpose of compensation or valuable consideration, you have to be licensed. But if you are going to do an assignment of contract, negotiate or deal in real estate contracts for no compensation or no valuable consideration, then you can do unlimited without a license here, which is kind of poorly written and pretty stupid. But basically, some ways around this is you just assign it without getting any money for it. Now you might be like, oh, but I gotta do money. Well, think about this. I can give it to my buyer for $0, and maybe he wants to, and maybe because he thinks I'm such a skilled real estate investor, he said, you know what? I like you, Zach. Why don't you become a partner on my deal here? And I'll pay you a little bit for helping me out on the flip of this house. Or you know what? Maybe I'll help you and get you the first month's rent on this property because I think you're a great partner for this deal. And maybe you get paid a portion of the rent as a partner with the buyer now, and you're not really getting paid for selling the contract. You're getting paid for part of the flip, or you're getting paid in part of the rent for managing the property. Now, those are just thoughts you can have out here, and you can get very creative. I think you guys are very smart, but there's a lot of ways around this law that technically don't follow under this definition. Now, it's up to you exactly what you want to do here. Talk to a lawyer and a title company and an attorney. I'm not telling you what to do or giving you any law advice. This is a bill, and this is what my thoughts, how you can get around something like this, or most importantly, just double close it. You're good to go. Don't be a real estate agent here. Now, for the other states that have actual passed laws about wholesaling real estate or assignment of contracts, there's actually 5 main states. And what I want to do is break down all these states really quick right now so we understand. Pretty much there's only one state that really has anything else, but let's break this down really quick. Number 1 is going to be Nebraska. So Legislative Bill 892 basically says, for the purpose of this section, acting as a real estate broker or real estate salesperson includes publicly marketing for sale an equitable interest in a contract for the purchase of real estate property between an owner and prospective purchaser. So you have to get a license if you are publicly marketing for sale. Now, do they have a definition of this? No. So technically you can't publicly market. Now, just hold on before I give you my thoughts on this. Oklahoma on House Bill 3104 here has pretty much the same definition. It shall be prohibited for any person, partnership, trust, association, or corporation, or the partners, officers, or employees of any partnership, trustees, or beneficiaries of any trust, association, or corporation do publicly market for sale an equitable interest in a contract. So this is basically the same law. No publicly marketing. What is the definition of publicly marketing? Well, you guessed it, there's no definition. But publicly marketing is giving now if you look at the definition of public, it's actually giving access to all people. That's the definition of the word public. So if you allow all people to see that you are having an equitable interest in your marketing to it, that would be illegal. Heck, what could this be? Posting your deal on Craigslist or Zillow that, hey, I have an equitable interest in my property. Yes, that is publicly marketing. But me maybe calling up my personal friend and telling him I have an equitable interest is private, not public. So if I text my mom, that is a private text. If I text the entire world or posted on the internet something to my mom, that is public. Those are clear definitions. Giving only one person access or a couple people versus all people, which is the word public, that's the biggest definition I found in my interpretation of this law. Business as usual. Just don't post your deals on Zillow and Craigslist because they're going to get stolen anyway. So there's 0 point to do this, and you can also double close. Do not need a real estate license for this. Now, Arizona has a bill called House Bill 2747 that passed, basically stating that wholesale buyers needed to give disclosures to sellers. Their definition of a wholesale buyer is a person or entity that enters into a purchase contract for residential real property as a buyer and assigns the same contract to another person or entity. So basically what's saying here is if you are going to assign your contract to another person or entity, you need to disclose it to the seller first. Now, I'd be like, whoa, that's actually a pretty big deal. Are they forcing people in Arizona to have a license to do this? No, because then boom, you're going to have to change the way or make assignment of contracts a thing where you can only have a license for it, which is clearly unconstitutional and stupid. What did they do instead? They basically said if you get caught doing this, there's going to be no financial problems or financial penalties because this is unconstitutional for us to do. Their big penalty is if a wholesale seller violates this section, The buyer may cancel the contract for sale at any time prior to the close of escrow without penalty and shall be refunded all earnest money paid by the buyer. Also the same way, if the buyer violates the section, the seller may cancel the contract at any time prior to close. Basically saying a wholesaler and a seller can cancel at any time prior to the close of escrow and keep the EMD. That's the big penalty they have, which basically means there's really no teeth or scary penalties for this, which makes the law pretty stupid. It's like if you're having a speeding ticket and the fine's 25 cents. Yes, it's illegal, but for 25 cents, what's the risk and reward here? Now, most people I know in Arizona already have a disclosure like this in their contract saying that the buyer may be a wholesale buyer, because you're technically not going to be a wholesale buyer for every deal. Can also double close this. Your intention is going to be different. So really, this is another stupid law. Now, the next state that has a law about wholesaling is Kentucky. And basically popping up this law here, House Bill 62, it says you need a real estate license if you are advertising for sale an equitable interest in a contract for the purchase of real estate between a property owner and a prospective purchaser, which says if you are advertising for sale an equitable interest, it's not saying you need a real estate license to assign your contract, but to advertise you need a real estate license. Now, does this law give any information of what advertising is? No. But really my thought is advertising to let people know that you have an equitable interest. So maybe you can't call your buddy and tell him you're doing it. But if your buddy calls you and says, do you have that for sale and do you want to buy it? Maybe you could do that, right? Like if it's illegal for me to advertise this microphone for sale, what if someone called me and says, Zach, I want to buy a microphone. Do you own a microphone? Yeah, I own a microphone. Well, I'm going to buy it. Can I buy it from you? Well, yeah, it's legal for me to sell this to you. You're good to go. I didn't advertise this. The guy called me. Technically too, I can call a bunch of cash buyers, see if they want to buy if they're interested in buying equitable interests when I have a property under contract. I'm not advertising an equitable interest in a contract because I don't have one right now. I'd have nothing under contract. There's definitely ways legally around this. So if a Kentucky real estate investigator asks me, you advertised that property. No, I did not. John Smith, he called me and said if I had any equitable interests in my contracts, and I said, yeah, I actually do have a equitable interest. I have a property at 123 Main Street I had under contract, and I have it currently. He said, can I purchase it for you? I'll give you a $10,000 assignment fee. Well, I wasn't planning on doing it. I was planning on double closing, but if you want to give me that, then sure, let's do an assignment of contract. I didn't advertise it. He called me up. We're best buddies. They're going to be like, dang it, I couldn't get you on that. But wait, how did you find that John guy? Well, actually, I was double closing a deal and I called him and seeing if he wanted to buy. Well, actually, I called him up and seeing if he was a real estate flipper because I'm trying to network with flippers, and he said he was, and we built a friendship from there. I, at that time, didn't have any equitable interests in any properties and I had no written contracts. So technically, I wasn't advertising anything there and you couldn't think of there. And now they're like, dang it, I can't get them today, Scooby-Doo. But really, that's how stupid these laws are written. You can get around this no problem. So this is why Kentucky is not like a thing I talk about too much, but it is a law. Now, the one state and the only state to have some sort of teeth or law about wholesaling real estate is Illinois. Now, up to this point, I want you to understand, up to this point, and for the past 4 years, and for the past years and years and years and years, there hasn't been one law curtailing us from wholesaling houses, double closing, or just doing what we're usually used to doing. There only has been one state, and this is the first state to make any laws. And in my personal opinion, this is a law that passed as unconstitutional. We've seen this time and time again where a state legislator will pass a law signed by the governor and the Supreme Court says, no, that law is not legal, and then they just strike it down. The process of that to happen first has to be someone has to sue the state and say this law is unconstitutional. Then it goes to appeal. Then it goes to the Supreme Court. Here's the issue. Somebody in Illinois has to investigate and find someone for wholesaling real estate in the state. But wholesaling real estate is protected, so no one's really even going after this. And here's the most important part before I give you the law. To investigate, fine, or get somebody in trouble for wholesaling real estate, first we have to define what is wholesaling real estate. What did you do? Did it break the law? This is like if a police officer tries to pull you over for speeding, you ask, what's the speed limit? And the speed limit has a question mark on it. Well, I don't know what speeding is. It has a question mark on it, but I want to pull you over for speeding. It's like, well, you don't even know what the law is. So how can you even enforce it? That's why speed limit signs have a little number on it. So let's get into the law here so we can really understand this. SB 1872 states that you need a real estate license if whether another or themselves engages in a pattern of buying or selling, whether for another or themselves engages in a pattern of business of buying or selling, offering to buy or sell, marketing for sale, exchanging, or otherwise dealing in contracts, including assignment of contracts, you basically need a real estate license. Now, most people think when it says to engage in a pattern of business that deals with real estate contracts, including assignable contracts, you need a real estate license. And this is saying here that if you're going to buy a house or sell a house, you have to have a real estate license, which clearly goes against the Constitution, contract law, and the contract clause, section 10 in the Constitution. Now, this is clearly really weird and stupid. Now, that was my interpretation of it. As the years have gone by, other people, including title companies' interpretations, have really changed on this. Because are they saying that if you are buying, selling, offering to buy contracts, or otherwise dealing in contracts, so if you are dealing with contracts, so if you are buying or selling contracts or dealing with them, do you need a license? Technically, could I double close here if I'm not doing an assignable contract? Because I'm not offering to buy and some people think that this law is only talking about buying contracts, selling contracts, or offering to buy or sell contracts, market for sale contracts, or exchanging contracts. This law is really weird because it doesn't say that you can't write contracts, only buying, selling, or offering to buy the contract. Now, can you tell this is all a run-on sentence? You've seen these other laws. They're written very clearly. Heck, look at the Oregon law. It's written very clearly. This was written to confuse and really make no sense of what's up with it. So if someone's going to say, hey, you're wholesaling, you can't do that, say, show me the law. Well, SB 1872 says, and they read this like, well, and I say, okay, well, can you define it then for me, officer or investigator? Like, was it me buying a contract that's the problem, or was it me entering in the contract? Well, it might be otherwise dealing, but it doesn't say you can't assign it. It says you can't deal in it. So I don't know. This is all one big run-on sentence that makes zero sense. So you don't even know the law and you don't even understand it. Heck, no one understands this law. So for over 4+ years, this law has been a thing. I've asked myself, okay, well, let's just make one person get attacked for wholesaling in Illinois. And then when they get investigated and they get arrested, like some wholesalers say, how about a judge interprets the law and says what you can't or can't do? Heck, there's been lawyers who have gone on YouTube to talk about this law and says, wait, the real estate license board is going to give us their definition of it. It's never happened. And the problem is no one's really enforcing this law or attacking wholesalers from wholesaling. To this day, there's people doing FSBOs, which is technically illegal with this law, and other things because no one knows the law and it's not being enforced. Heck, most wholesalers are just double closing and the title company is okay with it, so they get money. And number two, they don't understand the law and no one's really clarified it, so they're doing business as usual now. And the more years and years and years go by that no one's enforcing this law and no one's really interpreting it, it gets more confusing and they're just like, well, I guess we can double close. I mean, we're getting no definitions of this and we're good to go. So that is the state of wholesaling real estate laws, regulations, and bans in the United States right now. I truly believe if any of these bans happen to someone, there should be case law for it. For example, there has been not one case of somebody who has broken this law being attacked, fined, or enforced that I have seen. If you have proof, please, I beg you, say it in the comments and show me the proof. Show me a mugshot of a wholesaler wholesaling. But you can't find it because these laws are actually against contract law in general. It's against common law. We literally got common law from England because they were writing contracts since the Magna Carta in the 1200s. And the contract clause in the Constitution states that we have a right to form and states can't make laws stopping the obligation of contracts. So contracts are clearly written to protect private consumers, and with the countless case laws about this, wholesaling real estate is protected, the art of selling or assignment of contracts. How the judicial system works in the United States, when somebody passes a law, they're not the supreme law of the land. What do I mean by this? Our smart founding fathers made 3 branches of government: the executive, judicial, and legislative, which means if the legislative branch gets crazy, which we see it happen all the time with that Illinois law, The judicial branch gives it a check and a power. It says, wait, the legislative branch went way too far because we actually have the founding fathers wrote this law. So I expect the judicial branch to check the powers of the legislative branch of saying, whoa, you went way too far here, which is what we call case law. So what's going to happen is if somebody gets arrested or attacked or fined in Illinois, that goes to the Supreme Court, and then the justices will make a decision on if that is a constitutional law or not. Every single day, state laws like the one in Illinois get banished, get say that's unconstitutional, and is not a real law anymore. Now, I'm not saying this out of my butt. Knowing our Supreme Court justices right now, 9 of them, there is currently a 6-3 supermajority of conservative justices. And every single conservative justice I have seen their case law and their readings are strict fundamentalists when it comes to what the founding fathers interpreted. There's 3 justices that don't care about that, but I'm not getting a political debate. This basically means that if a wholesaling real estate law or ban goes to the Supreme Court justices, the 6 supermajority Supreme Court justices are going to say, hey, what did the founding fathers interpret in the Constitution? Well, they're going to read the contract clause in the Constitution. They're going to look at the case law, and they're going to show, yeah, this is common law. You can't ban someone from forming contracts. You can't ban people from buying and selling real estate without a license because it is fundamental in the United States of America to buy and sell houses without a license. Ben Franklin, George Washington, every single founding father you've known has bought and pretty much sold real estate without a license because that is a founding principle of the United States of America: freedom, entrepreneurship, and a free market. So that's why I don't get too worked up, crazy, heated, but wholesaling real estate is the best industry to get into, and it's an industry of entrepreneurs. Entrepreneurs are free market people. We are just not wholesalers. Heck, I'm not just a wholesaler. Yes, I make a lot of money wholesaling, but I also am a real estate investor. I own lots of rental properties. I invest in stocks and bonds, and I do other businesses on the side. I am a general investor and real estate investor. I am not a wholesaler. So if you want my full breakdown of all the laws, information graphics, links, and really a detailed breakdown on a visual format of all the laws in wholesaling real estate and regulations, make sure you scroll below to the description of this video, and I'm making my own regulation and law section in wholesaling real estate so you can make your own education and actually become informed. It's in my free real estate wholesaling course, freewholesaling.com, where I teach you wholesaling real estate absolutely for free. I give the information out for free. I'm not here to restrict you. And until the day I die, I'm going to teach you how to wholesale real estate for free, no paywall, where you can get the information that you need to become successful wholesaling real estate. I live, eat, and breathe wholesaling real estate, and this is my biggest passion in my life. And I think it's important to have open dialogue about this. And if you have any dialogue or thoughts on this, make sure you let me know in the comments. This is Zach signing out. Have a blessed one.